In a ruling that will have major implications on the GST framework and center-state financial relations, the Supreme Court of India on Thursday said the recommendations of the Council are not binding on the centre and state governments. The observation followed a judgment over the applicability of GST under the reverse charge mechanism on transportation of imported goods through the sea route. The Apex Court dismissed an appeal by the centre against an earlier Gujarat High Court judgment that said that integrated GST on ocean freight is unconstitutional. The Supreme Court held that GST Council's recommendations will only have a persuasive value, adding that the Parliament and state legislatures possess equal powers to legislate on GST. Abhishek A. Rastogi, a partner at Khaitan & Co., who argued on behalf of the importers, said there will be a pragmatic approach to the provisions which are subject to judicial review by way of challenge to the constitutionality of such provisions based on GST Council's recommendations. The decisions in the GST Council are taken by a majority of not less than 3/4 of the weighted votes cast. The centre has 1/3 weightage of the total votes cast, and all the states taken together have 2/3 of the weightage. In the last 5 years of GST, the Council has taken all decisions on the basis of consensus, with the exception of the levy on lotteries, in which voting took place in December 2019.
We challenge the constitutional validity of the levy per se on various grounds. The revenue argued that these changes in law were incorporated basis the recommendation of the GST Council. The answer is like this.
Yes.
The recommendation has a persuasive value. You must implement that recommendation, but you must not do something basis the recommendation which is unconstitutional. The GST Council will keep giving the recommendation. The process of voting, the weightage of the federal government and the state government all remains intact. But what the court order says, or those provisions which are based on the GST Council recommendation, but those must be taken only as recommendation. They will still have to cross the constitutional barrier or will have to test the constitutionality. But for instance, if there are certain policy decisions, the GST Council must keep into mind the cooperative federalism, must keep into mind the harmonized system which it needs to follow. But now today, if the two states decide to have two different rates, that will completely defeat the objectives of GST. Court very clearly says that one, GST Council has only recommendatory role. The recommendations will have a high persuasive value.
Yeah.
But that does not mean that tomorrow the states deviate. The state will have to debate if they want to deviate against the general principles.
The Finance Minister of Tamil Nadu, Palanivel Thiagarajan, welcomed the court's observation, saying it clarifies issues that he had raised last year. He had said the GST system and the Council function with an all-encompassing mandate not envisioned in the Constitution of India. He said the vesting of enormous de facto power in bodies not directly connected with the GST Council, such as the Tax Research Unit of the Central Board of Indirect Taxes and Customs, the GST Secretariat, and the GST Network, is fraught with questions of constitutional legitimacy. What would the Supreme Court's remark mean for center-state relations going forward?
This will lead to a lot of interpretational issues in relation to whether the states have their own respective powers to go ahead and legislate separately or not, or how the cooperative federalism will, now going forward will be followed in this country. My view is that there will be a lot of, I would say, a lot of litigation on various aspects and which will ensue. The concern which has been raised by them is that most of the powers related to levy of the taxes is now vested with center. Though they all are part of that collective decision-taking process as part of the council, but what they still feel is that we have to go by what is the agenda which is set primarily by the center. The council does not leave the states with any independent powers to look at their specific needs. And that's where they are welcoming this particular observation. The decision of the Supreme Court will definitely give more teeth to the respective independent states to raise their concerns and say that, okay, even if the council is not agreeing, I may have my own authority powers to look at that particular issue from my state's perspective. But that's is the worrisome part. Whether that will happen or not, if that starts happening, then the whole concept of one nation, one tax, and one process, the whole structure of the GST may fall apart. That's the concern that we all have. But yes, I think center will also have to now be more accommodative.
Another legal expert says that yesterday's ruling does not change the way in which the GST Council functions.
It definitely gives more ammunition to the states to negotiate and put forth their points. But that would also not mean that, so the majority view will not be overruled by a minority view. So that is definitely not the case. But yes, as far as the states are concerned, this does give them a bit more leverage. The law has always been the same. There is no change as such in the constitution or the provisions pertaining to GST Council. The constitution itself in Article 279A provides a mechanism where the GST Council itself can decide and deliberate on any kind of difference of opinion between states and the center, or between two or more states. So the GST Council itself has the power. So in any case in future, if there is ever a difference of opinion between the states and the center, the GST Council itself is empowered under the Constitution to decide on those differences.
Meanwhile, Revenue Secretary Tarun Bajaj said the ruling is unlikely to materially impact the One Nation, One Tax regime, as it is only a reiteration of the existing law that gives states the right to accept or reject the Council's recommendations, a power that no one has exercised in the last 5 years. The official further said that states never went back and framed legislations that were not in line with the panel's recommendations, even when they differed on tax rates on a particular good or service in the Council. To sum up, the SC ruling affirms that GST Council is merely a recommendatory body and its suggestions must pass the test of constitutionality. The states have also gained some bargaining power and can put forward their concerns before the GST Council more strongly.
If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.